All right, so we are going to formally commence the webinar for today. I'll introduce myself. My name is Brendan Zhu. I'm the Manager of Industrial Relations and Legal Policy here at Restaurant and Catering Association. And so if you have ever called the IR hotline, need any advice, you would have been dealing with myself as I assist our members with their employment law and IR-related matters. I'll firstly begin by doing acknowledgement of country, and of course want to acknowledge the traditional owners the land which we meet and currently on, both all those past, present, and future. And in particular, I want to acknowledge those who are on the Zoom today who may be from an Aboriginal or Torres Strait Islander background. As I mentioned a tad earlier, we've seen a huge demand for this topic. This one and our skilled migration webinar, probably the top two webinars that we've certainly seen on our end at R&CA. And it goes to show the importance of our membership and your feedback. The skilled migration webinar is a good example of what we're hearing from the industry and what is important to you that we can therefore have a webinar on. This one's slightly different. This one's more proactive in the sense of some changes that are coming from the Fair Work Commission that will affect our members. And we decided to do this webinar as a result of that. And so those changes are important. They're quite significant. And as a result of that, we've seen a great result with the registration, even those who are ticking in through the attendees at the moment. And so at R&CA, we want to represent our members, in particular in hospitality and restaurants, cafes, and the catering industry. And one of the big things, of course, more recently we're seeing is the skills shortage. So the immigration hotline, which we've just announced, is open for our members. And so that's something for you to think about. Our wages table, which is something that is super exciting as well, which one we will announce at the end of this webinar, is actually done by Simon O.B., who I will more formally introduce in a moment. Simon O.B. from EI Legal, who works extremely hard on all the wages table year in and year out, is going to be released for the Restaurant Industry Award as well, and the Hygo Award, which we will have at the end of this webinar. As I mentioned earlier, any questions, put in the Q&A section, and after the presentation, I'll moderate those questions for our presenters. But formally, I do want to introduce our presenters on this important topic. We have Simon O.B., who is the principal lawyer of EI Legal. And we also have Brooke Brown, who's a senior HR business partner from Employment Innovations. And what I'll do is I'll leave it to them and let them take it away from here. Thank you.
Thanks, Brendan, and good morning, everyone. I'm just going to try and share my screen, so hopefully this works. Can you see that, Brendan? You can see the slides? Yeah? Okay, very good. All right. So just by way of a bit more of an introduction, I'll start off with an apology. I've got a bit of a ticking cough, so I hope that's not too annoying for everyone. I will try and mute myself strategically to clear my throat. But yeah, Brooke and I work for Employment Innovations. Our kind of mantra is to make employment easier, and we do that through various services. We have outsourced HR and payroll services. We sell HR software and payroll software through our two sibling companies, if you like, Employment Hero and KeyPay. We also do work health and safety services, and we have a law firm called EI Legal, which I head up. We just do employment law in EI Legal, and we've got a long partnership with the Restaurant and Catering Association, and occasionally we get work referred over, and we do lots of work with the association generally, and have done for many years. And we work a lot across lots of industries, but we have a huge number of clients in the hospitality and restaurant industry. So it's great to be here today with all of you. So that's enough about me. I'll hand over to Brooke to tell you a bit more about herself and what she does at EI.
Thank you, Simon, and it's good to be here. Thanks everyone for attending. I'm a senior HR partner for Employment Innovations, and I work very closely with many businesses in the industry, including restaurants and hospitality. As a HR partner, I work very closely with senior management, business owners, and line managers. The partnership between Employment Innovations as a HR partner and businesses within these industries are very reliable, reliant on system infrastructure, and EI provide clients, as Simon mentioned, with technology such as KeyPay and Employment Hero. KeyPay is a payroll software, and that supports, I guess, the real intricacies of the industry and help them manage things like time and attendance and automated award interpretation. Employment Hero is the HR infrastructure, and that deals with everything from onboarding to sharing policies and procedures and employment contracts. So those two platforms are very significant, and they're well placed within the industries that we work with and support the partnering service that we provide clients. So excited to be here today and go over the changes with Simon, and hopefully we touch base with you all at some point after the webinar.
Thanks, Brooke. So we'll jump into it. Were you going to do the agenda? Is that your bit?
Yeah, I'll talk over the agenda for today. So the main points we'll go through is mainly to do with the current changes, the current way system, the salaries are paid under the Restaurant Industry Award, and how these changes will look come 1st of September. We'll also go over the new outer limits rules, which is the main changes from the 1st of September. This will include what is allocated to penalty rates, what is allocated to overtime rates, and what we need to be aware of. We'll also work through a practical example of what patterns of hours may look like for your business, and a set example of when overtime and penalty rates would need to be paid. We'll also talk about record keeping legislation and how the changes will impact meal breaks and reconciliations. Simon will discuss the written agreements we'll need to go into come 1st of September if the employees will be remaining on an annualized salary. We'll also briefly touch on the HIGA changes. Most of the changes are like for like, but we did want to briefly discuss this because we know that businesses will sit within that award also. And we also wanted to touch on some considerations that you may want to discuss and think about as a business owner or a manager if you were to pay over the minimum salaries under the Restaurant Industry Award. We'll talk through a few frequently asked questions that we've seen leading up to these changes. And then I will briefly talk over the practical next steps that we recommend businesses consider and take into account come 1st of September and leading up to that date in the next 2 weeks. Thanks, Simon. I'll pass that on to you.
Great, thanks, Brooke. So, look, we'll start off by looking at how annual salaries currently work under the Restaurant Award, because obviously to understand what the changes are, you need to know how things operate at the moment, and a lot of this may not be news to you, so apologies if we're going over familiar ground. All the detail that I wanted to discuss is on this slide, and I'm sure we will share a copy of the slides post webinar, but I thought it might be just as easy to look at the award itself. So Brendan, can you see the award there? Is that swapped over to showing the award? Yeah, okay. So basically in the Restaurant Award, and as I say, as Brooke said, the HIGA is very similar, and we'll come back to the HIGA at the end. But There is a provision in the award, clause 20. It says it applies to all employees other than casual employees. So we're talking full-time and part-time employees. And this provision allows employers to pay an annualized salary by agreement, and that is key, to employees. And it says that the annualized salary must be at least 125% above the minimum weekly rates that would otherwise apply, and the minimum rates are set out in the award. So it's the minimum weekly rate, 25% on top of that, and then expressed as an annual figure. What happens? What right that gives you if you pay this annual salary with at least this 25% buffer is expressed in clause 20.4, and it says that the annual salary will then satisfy the award in relation to penalty rates and overtime. But you need to read that in the context of the other provisions within clause 20. And what those, how those operate in essence is if you pay this 25% buffer when an employee works overtime, for example, working over 38 hours, or when they are entitled to a penalty rate, for example, doing their ordinary hours at the weekend or in the evening, there isn't an obligation to pay the penalty rates or overtime hourly rates at that time. So you just pay the set annual salary with the 25% buffer. But that's not the end of the story. The remaining provisions in the clause basically provide, and this is 20.5, that there must be what's called a reconciliation. That term's not used in the award, but that's how it's really referred to. And that reconciliation is a comparison between the salary that they were paid with the 25% buffer and what the employee would have been paid if they had been paid strictly in accordance with the award for each hour of overtime and penalty rates and the like. So it is a comparison that needs to be done, the award says, every year, or when the employee's employment ends, and any shortfall between the salary that was paid and what the employee was paid overall, and what the employee would have been entitled to overall with the overtime and penalty rates they would have been entitled to. You need to compare the two, and if there is a shortfall, that shortfall needs to be made good. There are some other provisions in the award as currently drafted, which are bear sort of noticing. One is that the annualized salary, it only refers to penalty rates and overtime. So the 25% buffer, if you look at it on a strict interpretation of the award, is only covering penalty rates and overtime. Doesn't mention annual leave loading, doesn't mention payment of allowances, and that's always been a point of uncertainty. That's cleared up in the new drafting of the award, as we will see. Now, for that reconciliation to work, for an employer to know exactly how many hours the employee has worked and what overtime and penalty rates would have been applied, there is also an obligation in clause 20 that says 20.9, the employer must keep a record of hours worked each day by an employee who has entered into an agreement under clause 20, showing the date and times at which the employee started and finished work that day. It goes on to say a record mentioned in clause 29 must be countersigned weekly by the employee and kept at the place of employment for seven years. And if you think about it, that's a necessary provision for the reconciliation to be able to take place, it's really important that a record is kept of all hours worked, so that reconciliation is reliable. And yeah, quite an onerous requirement there that the employee needs to countersign that to confirm it is accurate every week. So I think that's all I was going to mention about the clause. Two other short points. There is a requirement here at 20.6 that an employee who is working under this agreement must be rostered to have a minimum 8 days off duty during each 4-week cycle of work. And also, where an employee is required to work on a public holiday, they are entitled to paid off time of equal length to the time they worked on the public holiday. So those are the provisions as they stand today. What you will notice from that drafting is there's nothing about a limit on the number of overtime or penalty rate hours that can be worked during that period. It is the employee's protection, I suppose, is through the reconciliation done at the 12-month mark or when their employment ends, to make sure that the salary has been sufficient to cover everything, and if it hasn't been, then the shortfall has to be made good. So I think before we look at the changes, it's worth just thinking about why a business would enter into this sort of arrangement as opposed to paying employees on a hourly basis. And I guess there's two things. Firstly, there's kind of simplicity and certainty that you're paying the same amount in a fixed salary every pay period. It might also be that you're required to pay an employee a salary because of their sponsorship arrangements, etc., if they're on a visa. But the other thing that I think is important is following these arrangements. If you follow them to the T, it means that you will never have underpaid your staff, because the way that the clause is set up is it allows you, in a sense, to underpay a member of staff in a particular pay period. If they do excessive hours, you don't need to increase the salary until you get to that reconciliation. So in a sense, it gives you, as I say, that ability to sort of lawfully underpay someone during the year. You haven't done anything wrong, so long as that you make good that shortfall at the reconciliation point, either at the 12-month mark or when their employment ends. But as long as you've done that, as long as you've kept the records and you make good the shortfall, then you won't have done anything wrong by the salary not being sufficient in a particular pay period. And that's the way it's operated for a good number of years. But the Fair Work Commission has decided to make some sweeping changes, I guess, to these provisions, which kick in on the 1st of September. And that is what we are going to talk about now. And the main change is, for the first time, there will be an outer limit on the number of penalty rate and or overtime hours that an employee can work within a 4-week roster cycle without being paid for them at that time. So there's now going to be a limit on the number of overtime or penalty rate hours that can be performed. If an employee works over those outer limits, then they will be entitled to a top-up payment at that time. And we'll work through exactly how that works as we go through the excuse me, the slides. But some other kind of more minor changes, or potentially more minor changes. The first thing is that clause 20 will now just refer to full-time employees, whereas we saw previously it said all employees other than casuals. Does that mean that you can't pay an annual salary to a part-time employee? No, it doesn't mean that. But what it means is if you are paying a salary to a part-time employee, you would need to make sure that the salary is sufficient to meet all the entitlements, overtime, allowances, annual leave loading at the time that they work. You don't have this ability to have this reconciliation process for a part-time employee where you make good any underpayments at the end of the year. That's the first thing to note. The other thing is that clause 20 will now refer to the annual salary and the 25% buffer, covering annual leave loading and allowances, as well as overtime and penalty rates. So that is a positive thing, because prior to these changes, it was always uncertain how annual leave loading and allowances fitted into the annual salary obligation. So that has been made clear. That's a really positive thing. As I've just mentioned, there's going to be an outer limit imposed, and employees will need to be paid for hours worked above the outer limit at the time that those hours are worked. The reconciliation is still in place. There's a few tweaks about that which we will come to. But one important point to note, and one that people have been a bit confused about, is the reconciliation still needs to take into account the outer limit hours that are paid. So if you're doing these top-up payments throughout the year, that is still included in the reconciliation. You are still required to do a comparison of what the annual salary that was paid was compared to what the employee was paid hour on hour, and you will compared to what the employee would have been entitled to hour on hour, and you'll see as Brooke goes through a worked example exactly how that works. The second point with that is you still need to do a reconciliation even if the employee never works outside of the outer limit of hours. The new provisions do allow employees to work a fair chunk of overtime and penalty rate hours, and if they are regularly working weekends, regularly doing overtime, it's unlikely that your 25% buffer is going to cover all entitlements, even if they never work outside the outer limits, and you'll see that through the example as well. There is no longer the requirement for time off in lieu when someone works on a public holiday. That has been removed from the clause. But remember clause 30.3 regarding payment for full-time employees where a public holiday falls on their roster day off, that there are still entitlements in respect of that. That is not amended by the changes to the award. Another sort of minor thing that has changed, that there is no specific mention in the annualized salary clause anymore about a requirement for an employee to have 8 full days off in a roster cycle, but that is still referenced in the ordinary hours clause in 15.3F, even though it isn't specifically mentioned in the annualized salary clause. So we'll take a bit of a deeper dive now into the outer limits. I see there's a few questions that have come in. I might keep going and we'll come back to those at the end, so we don't get sidetracked. But we will come back to your questions. We're keeping a note of those, so we'll go through those in a bit. So let's take a bit more of a deeper dive into how the outer limits work. So the first outer limit, there's two. There's a limit on the penalty rate hours, and there's a limit on the overtime hours that can be worked. So the first outer limit is about penalty rates, and it is saying that the outer limit is 18 penalty rate hours per week, an average of 18 hours of penalty rate hours per week, averaged over a 4-week roster cycle. But there is a carve out for any hours worked between 10 p.m. to midnight on weekdays. So the hours which attract penalty rates under the award for ordinary hours are Monday to Friday between midnight to 6 a.m., where there is a $3.55 per hour or part of hour worked extra payment to be made. Then Saturday is at 125%, Sunday at 150%, and public holidays at 225%. So this is where an employee is working their ordinary hours on any of those days. We're not talking about overtime, we're talking about their ordinary 38 hours, but they have been rostered to work weekends, public holidays, or evenings, which is going to be, you know, that very, very common in the restaurant industry. So, as I say, there is an exception for hours worked between 10 p.m. to midnight, Monday to Friday. Those hours do attract a penalty. They attract an extra payment of $2.37 for each hour or part of an hour worked. But those are excluded from the outer limit of the penalty rates, because it is accepted that lots of employees are going to be working those hours. So there is a limit, I say, of 18 ordinary hours per week, averaged over a 4-week roster cycle. The roster cycle can't be longer than 4 weeks, so it's a 4-week maximum. And how the award will work going forward is if an employee works in excess of 18 penalty rate hours per week, they must be paid for those hours at that time. So, you know, if you're rostering employees to work Saturday, Sunday, and evenings, it is fairly likely that you might require them to be working more than 18 penalty rate hours. So this is something which is likely to come up. That is the rule in respect of those hours, and they are obviously, when they are paid at the applicable award minimum rate with the penalty attached. So it works in a very similar way for overtime hours. The outer limit is an average of 12 overtime hours per week, again averaged over a maximum 4-week roster cycle. And as you'll know, there are various ways in which overtime arises under the award, working in excess of 38 ordinary hours per week, working over a maximum of 11.5 hours a day, and various provisions about not being provided with sufficient breaks, etc. So the award allows or will allow from 1st of September onwards a maximum of 12 overtime hours per week. So that is obviously 38 plus 12 is a 50-hour week. If they work in excess of those, then again they need to be paid for those at that time at the applicable overtime rate. So I hope that makes sense, and you'll see when Brooke goes through her example how that might play out in practice. So just some points to remember again. Going forward, these new arrangements would just be for full-time employees, not part-time employees. And remember, another key point, just because an employee might work within the outer limits doesn't mean that the minimum salary plus the 25% buffer is going to be sufficient to meet all the entitlements they're owed to. If they're working regular weekends, they're working regular overtime, it's very likely that it's not going to be sufficient. So you still need to do that annual reconciliation, or the reconciliation when someone's employment ends throughout the year, and we'll go through how that works in a bit, but you still need to do that and make good the shortfall. So Brooke, can I hand over to you to take us through an example?
Sure, thanks, Simon. So now we're going to work through a couple of key examples. The first one mainly being reflective of a possible low to mid-season kind of arrangement. So using the first example, I'll just set the scene in terms of what we're working with. So we've got a chef de partie on a level 4, and this particular person, the minimum salary that is in line with the level 4 classification is around that 58,000 mark. Based on the patterns of hours that you see in front of you, we've looked at a Wednesday to Sunday roster, which is quite typical within the industry. So that's a 5-day working week. And as you can see, the start and end times vary on those days, which again is quite typical of the industry. Those rates that are an extension of those days allocate a shift cost. So you'll see in that column under shift cost, that is the total amount an employee would be paid if they were on a full-time hourly arrangement. So this is based on a 40-hour week. So if we were to make a quick assumption, that would incur 2 hours of overtime. So 2 hours of overtime clearly comes under the threshold of 12 maximum hours per week, because that is allocated to just the weekly overtime, and we haven't incurred any overtime in respect to shifts. The other hours that we would be looking at is the penalty allocation. And the penalty allocation comes to 15.5 hours, and that's for the hours worked on Saturday and the first part of the shift on Sunday. And what I want to make clear is the hours can only be allocated in terms of outer limits to one part of the allocation. So as you can see on Sunday, the first 6.5 hours is allocated to the Sunday penalty allocation, and the last 2 hours, which is over 38 hours, is allocated to overtime. So we can't double dip in that sense, which is great for employers, and only those hours will ever allocate to one outer limit category. So in this example, there's no need to look at the outer limits and make a payment for that. We can see we clearly come under that threshold in this example. Moving over to example 2, Simon, if that's okay. Okay, no, just wait for it to load. Okay, so with example 2, we've used this example more so for possibly a higher end of the season, say coming into summer, which may be timely where we kind of land within the calendar year at the moment. So using the exact same example, the same classification and the same role and the same minimum salary, I've amended some of the patterns of hours. So it's still a Wednesday to Sunday roster, which is typical within the industry, that maybe the days in which the employee works may remain the same. However, coming into the high season, the start and end times and the duration of those times is likely to increase based on operational needs. So you can see in this example, we're working with a 45-hour week, which automatically we can land at the assumption we've got 7 hours of overtime as a minimum that will be allocated to that outer limit allocation. I've also put Wednesday as a possible public holiday. We could work with a public holiday on a Wednesday, such as Anzac Day. Within that allocation, public holidays will be allocated to the penalty hour category. So working with this example, we can see that on the Wednesday and Thursday, the person has had less than a 10-hour gap between shifts, which means that whole shift on Friday, because we've ended at midnight on Thursday and we've started at 8 a.m. on Friday, the whole Friday shift will be allocated to overtime. And because there was a less than a 10-hour gap between those two shifts, meaning those total 8 hours will be allocated to that overtime category. In addition to that, we'll see at the end of the week, the employee has done more than 38 hours as well, which means the 7 hours will also be allocated to that outer limit allocation. So using this example, the penalty hour allocation equates to 18.5 hours, which is the public holiday shift. And that is that Saturday shift, because the Saturday shift is in isolation of any overtime hours. The Sunday shift is a total of 7 hours, which means that whole allocation is not to the penalty hours, but rather to the overtime hours, which supersedes that amount. So we can see that the penalty hours has gone over by a total of 30 minutes because the maximum thresholds is 18 hours and we're sitting at 18 and a half. And the overtime hours is allocated at 15 hours, which includes the minimum. There was not a minimum gap of 10 hours between the Friday and Thursday and Friday shift. And also that whole Sunday shift is going into overtime because the 7 hours is on top of the 38-hour week. So looking at this example, we will need to calculate in this particular pay period with the new changes, how much we owe the employee outside of that outer limit threshold. So 30 minutes of penalty hours, we can see equates to $88, and 3 hours, which is over the 12-hour threshold because we landed at 15, equates to 142 hours. So within that particular pay period, we would be obligated to make a payment of $230.78 to work in line with the provisions that are coming into place as of the 1st of September. If we were to look at, I've just noted within that example as well, what an annual, if that salary, if we had that high season throughout the whole course of the year, what that forecasting amount would look like. And we're sitting at about 90K. So you can see the severe impacts of overtime and penalty rates if we aren't keeping them quite tight in how we're rostering. Moving over to the assessment, Simon, if that's okay. So to put it all together, I've combined calculations of both examples. So again, using the same classification, using the same minimum salary. I've used the first example for an example of a low to mid-season 40-hour week, not doing a lot of overtime, not doing a whole heap of penalties. I've used that example for a 9-month period of the year, and that equates to $43,000 if we're looking at a reconciliation amount, if we're looking at the timesheets and what they would have earned as a full-time hourly employee. Then I've used example 2 as a reflection of a possible peak season, and I've put that over a 3-month period. So possibly you could equate that to a summer period. That will give a total of a 12-month period, which is the period in which, despite if the employee leaves, if the employee remains employed for that whole period, we'd be obligated to look at a 12-month reconciliation payment. What I want to note within this last assessment is a point that Simon touched on, that any outer limits paid within that 12-month reconciliation period will be deducted off the total reconciliation amount. So it will contribute to the total payments you've made to the employee. So we'll see in this example, this employee was paid $58,000 throughout the year. The reconciliation comes to a $66,000 figure. The outer limits payments that were made to the employee equates to around $3,000, which is just the example 2 times 3 months. It's just a forecasting amount. Remember, these are all estimates, purely for an example base. So that means we can take off $3,000 from the total reconciliation amount, which means the outstanding reconciliation payment is not a total of $7,000, but rather a total of $4,882.30. I hope that makes sense. There's a lot to digest. Simon, jump in if you think I've missed anything. But I think this shows clearly where the reconciliation provision still is very relevant and still is something we need to be aware of, with also then taking into account the new provisions and how that works in line with kind of our old operations, what we're used to today. So that you can clearly see that 25% buffer that we pay employees, despite the outer limit payment provision coming in, which was a total of $3,000, we still are quite, it's quite onerous, and we would still be outstanding in this respect using this example.
Thanks, Brooke. No, that's really really helpful. Yeah, and I think brings all the points home. But yeah, it shows you just kind of how complicated these things can be. So let's excuse me. Let's keep going. We've talked about the outer limits, and that is obviously the biggest change. There are some other changes around the edges, if you like, that it's important to be aware of. One is that at the moment the obligation to keep a record of hours worked, it only references to starting and finish times. Going forward, you are going to have to keep a record of unpaid breaks taken as well, where in reality, I think that would have been necessary anyway for the reconciliation to be accurate, but now it is stated clearly in the new provision in the award. The record must be signed by the employee. It now says or acknowledged as correct in writing, including by electronic means, and that is obviously to make it easier for employers and employees that use, software and rostering situations, systems. You don't actually have to get the employee to physically sign something, ticking a box or confirming. Yes, I agree, will be fine. And the requirement to do that is no longer weekly, it is each pay period or roster cycle. There is a specific reference now to the reconciliation being performed and any shortfall being paid within 14 days, whereas currently under the award, it doesn't give you a time limit, but there is now a clear 14 days time limit to make good any underpayment. So that will run from the date the employee's employment terminates, or the 12-month anniversary of when you enter into one of these annualized salary arrangements. The other new provisions to be aware of are those that deal with the written agreement that must be entered into with employees who you are paying under these arrangements. And I suppose the first point to note, and this is equally applicable to the situation as it is today, is that this is an agreement. This isn't something that can be forced upon an employee to be paid a salary. It needs to be by agreement. That agreement has to say the amount of the annualized wage that is payable, which of the provisions of the award will be satisfied by payment of the annualized wage, and there are the provisions listed in the clause which you're able to satisfy: overtime, penalty rates, annual leave loading, allowances, etc. So generally you will be listing all of those, I expect. The outer limit of number of hours of overtime and penalty rate hours that can be worked has to be specified in the agreement, and you don't have any choice about the number of outer limits. We've just talked about what those mandatory requirements are, but that needs to be stated in the written agreement going forward. Now, that is something obviously which is new. We haven't had an outer limit to date. So what that means in practical terms is any written agreement you have in place at the moment will need to be updated, because unless you could see into the future, you wouldn't have included an outer limit in your written agreement, but that needs to be included going forward. So that means from 1st of September, if you want to continue engaging staff through these annualised arrangements, you're going to need a new agreement which refers to those outer limits. The final point on this slide is that the award will also say going forward that the agreement may be terminated by the employer or the employee giving 12 months written notice of termination, or at any time by written agreement. So that means that it is possible at any point that an employee may say, this annual salary arrangement isn't working for me, I'm giving you 12 months written notice. When you get to the end of that 12 months, you will need to revert to paying them an hourly wage in accordance with the award. So that is something new. Just to finish off, looking at the HIGA, the provisions we've talked about are pretty much identical in the HIGA. The main difference, so the same number of penalty rate hours outer limits and overtime hours outer limits apply. There is a slightly different provision that says that the penalty rates which are excluded from the penalty rate outer limit are hours worked between 7 and midnight. So that's slightly different to the restaurant award. And the other thing which is different is that clause 35.3a regarding payments for public holidays falling on a full-time employee's rostered day off is specifically mentioned in the clause. So that is included within the annualized salary. That for some reason that isn't something which was mentioned in the restaurant award, so that for restaurant award employees that still sits outside of that arrangement. The other point to note in respect of the HIGA is none of these changes affect annual salaries for managerial employees in hotels. So maybe I'll just flick to the award. Hospitality award, unlike the restaurant award, has a different provision regarding annual salaries paid to managerial staff in hotels. And basically what that says is you can pay a manager the 125% buffer on the minimum wage, and that will cover basically all entitlements to allowances, overtime, penalty rates. There's no obligation to do a reconciliation and make it a shortfall. That salary covers basically everything. That is just for managerial staff at that, I think it's level 7 level, and there is a very strict definition of which roles fall within that. So that hasn't been upset or changed by the new provisions at all. but for all other employees, you're looking at the outer limit provisions akin to what we've discussed, excuse me, with the restaurant award. So I hope that makes sense. So one of the things that has come up with clients that we've been advising and that Brooke and I have spent quite a bit of time thinking about is it is fairly obvious how these new provisions work, where you are paying an annual salary which is exactly in line with the minimum salary set by the award and the 25% buffer. Pretty clear how it's going to work going forward. Whenever someone works outside of the outer limit hours, you need to pay them at that time at the award rate. That fairly simple, regardless of what you think of that as a concept. But what happens if you're paying employees higher than that minimum annual salary, which is likely to be the case for at least sort of your more senior staff, I guess. So in Brooke's example, we were looking at a level 4 employee minimum salary under the award with the 25% buffer of 58,467. What if you were paying that employee a salary of, say, 70K? What happens then if that employee works outside of the outer limits for overtime or penalty rate hours? Do you have to pay them the award minimum rate at the time, regardless of the fact that they are being paid this over award salary? And as you would expect with modern awards, that there are several things which the award doesn't talk about and leaves it open for interpretation. If you look at the wording of the new provision, I've quoted it there on the slide. It says, if in a roster cycle an employee works any hours in excess of either of the outer limits specified in clause 20, such hours will not be covered by the annualized wage and must separately be paid for in accordance with the applicable provisions of this award. So if you have given an employee an annualized wage of an amount above the minimum wage, you can see that there's a clear argument that they would have to be paid those additional amounts regardless of what you've set that annualized wage as. We think it's likely to be the case that there are some methods of dealing with that, so that's not how things will work. It is something, if you're doing anything outside the exact provisions of the award, you really want to seek some professional advice. So this is just a general comment, and we're by no means making an assurance that this would be possible in all situations. So please do seek advice if you are thinking of going down this route or something similar. But we think it is possible that you could arrange things so that in a situation where you're paying someone, say, a 70K figure and the minimum payment is 58, if you expressed to the employee in their written agreement that their annualized wage was the minimum wage, was 58,467, and you expressed that if they worked above outer limit hours, that they would be paid additional amounts. If you then said that in addition to the annualized salary, they are paid an amount which is an over award payment. So in this example, it would be an over award payment of $11,000 there or thereabouts over the year, spread evenly over each pay period. We think it's likely that you could then allocate that over award payment towards the payments of outer limit payments that arise in that pay period. But it would be very important that that was expressed in a way that their annualized salary is not 70k, it's 58k, but we have an additional over award payment that we are paying to you every pay period, and we can allocate that to these other entitlements that arise. We think as long as that is expressed in a clear way, it is likely to be possible. It will also be important that in pay slips and in pay records, it is shown that the employee is being paid for those above outer limit hours. So those are recorded and those are shown, hour by hour. It is just that the payment for those is met by this bank of over award payments that you've allocated as this separate sort of payment fund for that. So we think there's ways to do that, but as I say, do seek legal advice if you are in that territory. If you are only paying a annual salary slightly above the minimum award salary, it might be simpler just to pay the above outer limit payments as they arise for the sake of being conservative. Can I hand back to you for a few FAQs?
Sure. Thanks, Simon. I think that covered. I was having a look at some of the questions that were coming up in the Q&A box, and I think that covered a lot of them. And hopefully these FAQs will do the same. I did see a question regarding some of these points. So can we offer, these are some FAQs we've put together that we've seen some consistency across clients to date asking similar trends. So the first one is, can we offer time in lieu instead of an overtime payment? So can we offer time off if that person goes outside the outer limits? I think there's two kind of parts to that. Clause 23.5, time off instead of payment of overtime, does not apply to the outer limit provisions. So you could use that clause if an employee went over into overtime under the outer limit threshold, but in terms of going over the outer limit threshold, that is a payment provision and that needs to be paid within that particular pay cycle. In terms of the outer limits, I think there was another question regarding this as well. Do outer limits need to be set per week? The answer is no. They can be set per roster cycle. So if we go back to those thresholds, it could be 36 hours over a fortnight, or in terms of the penalty rates, and 24-hour threshold over a fortnight in terms of overtime rates. So depending on how you roster your staff. Are there any other important upcoming changes that we need to be aware of? Funnily enough, they love to introduce these things that don't coincide with other things that are super important. So from the 1st of October, minimum rates will be introduced. But just to note, these changes come into effect as of the 1st of September. So as a business owner, from a HR partnering perspective, I would definitely take that into account whilst you're doing these assessments. If you are increasing rates, I would recommend, once these rates are published from the R&CA after this webinar, I would definitely take that into account come the 1st of September. Otherwise, we're going to need to relook at that again in October. And I would use that opportunity if we were recontracting staff to do it all at one time, and just give them an extra month kind of bonus if they do need to up their rates. Moving on to the practical steps, Simon, if that's okay. This is a bit of a summary of where we landed and what I've recommended to clients to date, but also leading up to these changes and what we need to do from the 1st of September. So starting off, it's recommended that a communication piece is sent to all staff who are on those annualized salary arrangements. This purely can be a simple notification outlining the new changes to the outer limits and record keeping obligations in terms of meal breaks and the requirement to clock on and off. So anything, I think that may be a big one, the record keeping kind of changes. We may insert some type of identifier if someone's had 30 minutes off, but it will be a change to how the employees kind of operate if they need to clock in and out for that particular meal, 30-minute meal break. Part 2 of this is looking at the assessment of technology and the infrastructure the business currently has. How will the current time and attendance operations that the business use and payroll systems work to support and manage these upcoming changes? So this is a really big one for my clients, and something that Simon and I discussed at length. It's so onerous, these provisions, and you really need strong system infrastructures to just be able to support and manage these changes. So to give you an example, KeyPay, which is our time and attendance and payroll system, has a function for rostering warnings. So when line managers are rostering the staff, we can set certain award rules that will flag in the system to say, no, we've gone over 12 hours, or no, we're going to go over the 18-hour threshold, and what change it will prompt them at the time of planning. So I think that's a really good tool for my clients' use, and maybe something that you consider and are aware of. In addition to that, the software, which I did mention before, has award interpretation, and any changes that are made to the award is updated in KeyPay. So we envisage that being a really good way to be able to manage these changes pay cycle to pay cycle. Part 3 of this is undertaking a wage reconciliation and a kind of roster assessment. So my recommendation would be to look at however you roster, if that be fortnightly, if that be weekly, and maybe take a few different samples from the different peaks and troughs of the year. So that may be in a low to mid kind of season versus a summer season, and then look at those rosters and consider whether you can make changes to avoid those annualized salary employees going over those outer limits. If you identify such roster change, the managers will then need to, in line with Part 4, consult with staff who require a roster change. So we would look at how we've been rostering to date and what possible changes we would need to tweak to keep them under those thresholds, or looking at the thresholds and knowing there's really no changes we can make, but possibly we could reduce some aspects in different patterns of hours. Part 5 of this is identifying staff who may be suitable for a full-time hourly arrangement, which I did see was a question in the Q&A box, and something that Simon did kind of touch on throughout the webinar. This could be a real opportunity to look at your current workforce, where they sit, and what changes we could possibly identify in terms of the arrangements we have in place at the moment. So I would use these next 2 weeks specifically to look at staff that may be suitable for an arrangement like this, and depending on the operations of the business, there would be different considerations of that. So you may have a staff member that works very consistently throughout the year, like the example I used before, which you've got 9 months that you are on a particular roster pattern that is quite consistent and in line with what we're paying. But then we've got a high season that absolutely skews that minimum salary and puts them over week on week in terms of that outer limit threshold. We may identify those staff that, because that process is so onerous, we may not have technology or infrastructure to support that. We may look at putting them on a full-time hourly arrangement. And how we want to upskill managers to be able to have those consultations, which is Part 6, is we would outline to them what that arrangement looks like. So essentially, you could look at bumping up, say, a minimum salary to then be coupled by real-time payments in those peak seasons. So essentially, they would be receiving similar take-home pay to what they're getting at the moment if we forecast accurately. However, they would be getting their overtime in real time, and we wouldn't need to worry about the thresholds. They would essentially get overtime from 38 hours onwards, and if you had award interpretation, it would be realized in that moment. So that is a real consideration that businesses may want to discuss after this webinar, and what that looks like. And if you wanted further advice on that, please do reach out, because that is definitely options that Simon and I are working on with clients. In terms of part 7, we would need to organise new employment contracts for staff that are moving on to a full-time hourly arrangement if you wish to do that, because it's substantially different to the arrangements of an annualised salary if we were to change that and employees were open to that particular arrangement. Part 8 is organising an annualised wage arrangement outer limit document for staff who are remaining on the annualised salary. So like Simon said, it needs to be a written arrangement. So our current salaries, unless you did forecast this change to come into place, would not be able to cover such arrangement, meaning we need to consult staff and make sure they're in agreement with that to then issue a new written document to confirm that arrangement. And then part 9 is from the 1st of September, ensuring all prospective staff, so not only existing, so confirm those existing arrangements first, but also make sure your full-time contracts, your salary contracts are up to date, which includes an outer limit section. And that's something that we'll be working on in the next 2 weeks to make sure all our templates, Simon, are updated in line with that. So they're the main things. Again, these are practical steps in terms of general advice. If you need anything specific to an individual or your own business circumstances, that's where we can help out. But I hope it gives a good kind of overview on what you need to do from now until the 1st of September.
Great, thank you, Brooke. No, some really useful points there. Brendan, that's the end of our kind of formal presentation. I'll pick up our contact details if anyone wants to get in touch. But do you want us to look through some questions? I'm aware we've kind of gone past 12, or
of course.
How are you feeling?
Yeah, so we've got a lot of good questions. What I will do is I've actually been putting them on a document and consolidating them all together to try and group them into relevant topics, just for the ease of the questions. So the first batch of questions is in relation to, I guess, the scenario where would this not apply? So for example, we've got a question here that if you're paying well above the annualized level 5 rate, so well in excess, and they're working on average of 40-hour weeks, would this issue still apply? Another question similar to that is there a salary position where reconciliation would not need to apply at all? You know, can you pay such a significant salary that you do not need to do this at all? Another one very similar to that is if an employee doesn't want to follow this new change that's coming into effect, can they sign an agreement to stay the way they are at the moment? And lastly, would a new agreement should be required if you're paying well above the annualized salary rate, so more than that 25% buffer? So that's the first batch of questions in relation to where could this potentially not apply?
Yeah, some really interesting questions there. If you wanted to avoid all of these provisions, but pay a staff member an annual salary, one option, which isn't going to be applicable to many staff, I should think, would be to enter into a guarantee of annual earnings. So a guarantee of annual earnings is an ability under the legislation that if you enter into this agreement with staff and pay them, agree to pay them an annual salary above the yearly high income threshold, it's called, then none of the provisions in the award apply. But the high income threshold goes up every year, and it's currently at, I would need to Google it, but it's about $160,000. So practically speaking, it is only your really well-paid staff that are going to be possible to give that sort of arrangement. You know, I'm sure 99% of the employees we're talking about are going to earn, you know, probably half that. So, but if you do happen to have, you know, you're a superstar employee that is being paid, around that 160K mark, it allows you to contract out of all the provisions in the award, and I'll double check that figure, but I think that's not going to really apply to many of the people we're talking about. The second way that you could seek to organise things is, although it doesn't say so in the award, the Fair Work Commission have previously on a number of occasions said that it's possible to pay someone an annual salary outside of the annualised salary provisions in the award. There's lots of awards which don't have annualised salary provisions at all, and it's well established that it's possible to pay those people an annual salary. But what that would mean if you do it outside of the annualised salary provisions in the award is you won't have this ability to underpay employees in certain pay periods and make that good as part of an annual reconciliation. If you're paying an employee an annual salary just through their contract, you're not engaging in these clauses, you have an obligation to pay them fully every pay period. So if you're paying them fortnightly, you need to make sure that that salary is sufficient to meet all entitlements that arise in that pay period. That will be annual leave loading if they're taking annual leave. If they're performing overtime, then it needs to be paid at that time. So if you have employees that you can do that for, then that is fine. But that is only really going to work, I would suggest, where you have employees who work fixed hours every week. That example of Brooke gave of a sort of consistent hours for 9 months of the year, but 3 months of high season where they're doing crazy overtime, loads of penalty rate hours. If you haven't set your salary to meet all the entitlements in that high season over, in each fortnight that arises, then you're going to have been underpaying them throughout the earlier months. It won't be the fact that the salary overall over the year might be sufficient isn't going to help you, because it's only relying on the annualized salary provisions in the award that give you that ability to underpay, to average things out over the year. If you're just doing it through a contract, then you need to pay entitlements as they fall due, which, as I say, practically speaking, that's not going to work unless you have employees doing fairly fixed hours, or if you have the ability to pay employees at a salary which is going to cover every possible bit of overtime they do, then I think that would be permissible. Otherwise, you're looking at making kind of top-up payments when they work additional hours, but then that defeats the very purpose of paying an annual salary. Mm-hmm. But those kinds of arrangements, as I said earlier, if you're doing something which is outside of the strict provisions in the award, that is really something that you want to get some individual advice on, because the consequences of getting it wrong are obviously quite severe. Yeah,
absolutely. The next batch of questions that we've got are in relation to the annual reconciliation, and so I've just put them all together. Performance bonus payments considered in the annual reconciliation? Is super and annual leave loading paid on the reconciliation payment? Is super and annual leave loading paid on overtime and penalty rates? And are you able to bank hours during a 3-month period where they, let's say, work less for that time period and then work more in a subsequent time period?
Okay, so kind of trying to pick some of those apart. I think with bonus payments, so long as those are expressed when you pay them as something which can be used as part of the reconciliation, then I don't see that they would be excluded from that. As long as it's made clear to the employee, you might receive a bonus, but if you do we're going to use that as part of your overall assessment. I can't see an issue with that, but again, it's not something dealt with in the award, so it might be something you want to seek some more advice on. The questions about super and annual leave loading might be something that we would want to give a little bit more thought to, and maybe we can put together an FAQ document just to address those points. I mean, generally speaking, you don't get paid super on overtime hours, so I can't see why you would why that would be different when it's being paid as part of a reconciliation or outer limits, etc. So my inclination would be super wouldn't be relevant to overtime payments, but would be on penalty rate payments. But yeah, maybe something we'd want to have a bit more of a think about. What was the annual leave loading question?
Yep, the annual leave loading one was, let me just grab it up, in relation to whether do employees accrue annual leave loading on overtime and penalty rates?
No, so it's the annual leave loading is stated in the award to be 17.5% of their ordinary rate of pay, or I think shift penalties if it's higher. I'd have to look at the provision in the award, but I don't think you would accrue extra annual leave loading on those payments.
Yep, no problem. Our next batch of questions were in relation to the record keeping. So if someone uses an online timekeeping program, but there is no provision for the employee to counter sign off at the end of the week, but they're the ones to record their hours, which are then approved by a manager, is that okay? Is that sufficient?
Look, I think it's gonna depend on exactly how things are set up, but let's look at exactly how it's worded in the new provisions. Where is it? So it's here, 24.3 C. I'm not sure if this is hospo or restaurant, but they're both the same in this respect. The employer must keep a record of the starting and finishing times of work and any unpaid breaks taken of each employee subject to an annualised wage arrangement agreement for the purpose of undertaking the comparison required by clause 24.3. This record must be signed by the employee or acknowledged as correct in writing, included by electronic means by the employee each pay period or roster cycle. I would take that to mean that the employee needs to see the final record, if you like, and for them to approve that record. So if your record is a timesheet completed by the employee, which they've said that this is accurate, I think that would meet that obligation. I don't think they need to hand it to the employer. The employer hands it back. They then sign it. But I would caveat that by wanting to know exactly how things are set up. It's impossible to be definitive without knowing exactly how things are set up. But that sounded okay from what I understood. But again, I'd encourage you to seek some advice on your own situation.
Not a problem. And then what if you pay someone well above the hourly rate, without entering a salary, do the outer limits still apply? And another similar question was, can you use the IFA, the individual flexibility arrangements, instead of paying the annualized salary?
Well, I think with the first question, if you're paying an hourly rate, the outer limits don't apply. You just need to make sure that the employee is being paid sufficiently in each pay period, and if your hourly rate is sufficient to meet all those obligations, then happy days. So the outer limits aren't relevant to employees paid an hourly rate. Using IFAs, look, it is. I think potentially they could be used to pay employees in an alternative way, but the key point with an IFA is the requirement that the employee is better off overall. And as soon as you start tweaking provisions of the award, you're heading into kind of unforeseen territory, if you like. A lot of people, when these record keeping requirements first came out, people were saying, well, can't we use an IFA to say we're going to pay you a flat rate and we won't keep a record of your hours in the way prescribed by the award? And I think there you are facing a challenge that if it came before the Fair Work Commission or a court, you can envisage that they could well say, well, how is the employee better off overall? Maybe you're paying them a nominal increase on the rate of pay, but they're losing this whole protection of having their hours recorded. So it's those kinds of arguments which make IFAs always it is always impossible to say with certainty whether an IFA would be upheld. So again, if you wanted to go down that route, I would suggest you get some professional advice. But yeah, I think IFAs as a silver bullet is rarely a solution to all problems. The other challenge, of course, you have with an IFA is it's can be terminated by the employee at any time. You can't make an offer of employment subject to an IFA, so you can end up with a two-tiered workforce where some people agree to it, some people don't. So yeah, there's definitely some challenges there.
And a similar one that we had before, if an employee is paid weekly, but slightly different, if an employee is paid weekly, can we still consider them to be on a monthly roster to average out the outer limits? And I guess, yeah, similar to the banking question, can you bank hours? So let's say you work less than full-time hours for, let's say, a month, but then the subsequent month after that, can you work in excess to accommodate for those banked hours?
Well, the roster period can only be 4 weeks, so you can only do that within a 4 weekly period. I don't see, if you're paying weekly, the same rules apply. You're still averaging the outer limit, or you're still able to technically average outer limit hours over a 4-week roster period. But Brooke might have some more on this, but wouldn't that practically be very difficult to do that if you're paying weekly?
Yeah, I've had this come up, Simon, before, and we discussed this before the webinar. Often employees do have different pay cycles to how they roster. You may want to roster if you can. I know the nuances of the industry can't often offer a 4-week roster cycle because it's subject to so much change. But if you can, that can, yeah, be different to the pay cycle. But I think what you'll fall into is some confusion from the employee side. So in terms of that relationship, you may want to consider some possible disputes or confusion around when that's payable if their pay cycle is weekly.
Excellent. And yeah, so I think there's a few, and there's a few that are responded to directly. If you have specifics on a particular case study or example, you may need to either call the IR hotline or for R&CA, or get in touch with EI Legal if it's in particular something you need in writing as legal advice. I have done my best to copy paste all the questions as well for the ones we haven't had a chance to get to. Can I firstly thank again Simon and Brooke for the presentation and for today. It's been a very important topic with a lot of questions. It's probably one of the ones that we have had no need to prepare questions beforehand, because the questions have been firing through thick and thin as well. And so thank you everyone for your questions. If you have further specific questions, as I mentioned, IR hotline on 1300 722 878. The wages table for the Restaurant Industry Award and the High Growth Award that Simon and his team have worked on is now live on our website. So it's now live on our member resources section of the R&CA website. And so check that out. That, of course, goes up on 1 October, but we are releasing it now for you to do any forecasting that you may need to do, as well as any projections and scenario planning. And so the R&CA for members, the wages table is now up as well on our website. There were a few questions in relation to migration, and also, the significance of the skills shortage and these onerous and burdensome requirements, as you've learnt about. And so we have launched at R&CA a new migration hotline and service as well. So get in touch with R&CA and you'll be able to be assisted with any migration related inquiries. And so, as we've mentioned, the recording will be there. We will share that with you shortly. The slides will be shared with shortly as well. And the team from Employment Innovations and EI will also be able to assist with your questions. We've had a few questions about Keeper and all the functions that they were able to do. And of course, they were able to do all the things that you have asked about. And so that's an important aspect of it as well. Thank you again for everyone for joining here today. Thank you again to Simon and Brooke for the presentation. And we'll be in touch with everyone very shortly through our various communications. Thank you.
Thanks,
Brendan. Thanks, everyone.
See you later, guys. Thank you.